everybody, I'm Greg Eisenhoff,
Sean Burns.
and today we're going to be talking about pretrial procedures. Now we're going to kind of outline what basically the duties of the prosecutor, the defense attorneys would be, as well as the pretrial process in dealing with motions. Then we're going to get into dealing with indictments and basically different things with plea bargaining. So with that being said, Sean, you ready to rock and roll?
Yep.
All right. So Sean, you want to start breaking down what you'll see on the first PowerPoint slide that you have. You basically will see basically from top to bottom of how the courts actually operate. And when you look at how the courts actually operate, you say, geez, what do the prosecutors actually do? So Sean, you want to give a quick breakdown of the slide of the prosecutors?
Yeah, so what this slide is of a state's attorney's, the organization of a state attorney's office in Maryland. The state attorney in the state of Maryland is the same as the county prosecutor here in the state of Michigan. So you'll find that prosecutors at the local level are known as, they have various names, assistant district attorneys, assistant prosecutors, assistant state attorneys. Those are all county prosecutors. It's all the same name, it's synonymous for the same position. But this is just how a typical office for the, in Baltimore, Maryland, how the office is broken down and organized.
And then like looking at stuff here in Kent County, I'll break down a quick thing here. In Kent County, like you'll have the prosecutor, we're gonna talk about those in a minute, but then you also have the assistant prosecutors. And they'll have assistant prosecutors, like one working specifically with sex crimes, one working specifically with drugs, and vice versa. So officers working the street, because if you see up here, it'll say like homicide division, you'll see kind of like breakdown stuff. You may have more specific prosecutors taking on more specific cases, and those are the ones that they'll take to court. But we'll get into that a little bit further as we break down the court stuff here. So let's look at the federal system. You want to talk a little bit about the federal system, Sean?
Yeah, so the first slide we're going to talk about here is the Attorney General of the United States. The AG is a cabinet level position. What's that mean? Well, that means that this person is appointed to this position by the President of the United States, or POTUS. They are appointed by the President, they are confirmed by the Senate, and they serve at the pleasure of the President. So what does that mean? Well, that means if they're not doing a job that the President thinks they should be doing, they can be fired, for lack of a better term. The person you see here pictured is Attorney General William Barr. William Barr actually came to be the Attorney General of the United States because he replaced Jeff Sessions. Jeff Sessions was President Trump's first Attorney General. President Trump didn't like the way Mr. Sessions was running the Department of Justice, so he asked for his resignation, which Attorney General Sessions gave, and President then appointed William Barr. So the Attorney General of the United States is recognized as the Chief Law Enforcement Officer of the United States.
So would you say there's a difference between the Attorney General and the U.S. Attorney, which we're going to kind of lead into right now?
Yeah, so this slide right here, it was talking about the U.S. Attorney. So throughout the United States, there's several different judicial districts. Here in the state of Michigan, we've got two. We've got the Western District of Michigan, we've got the Eastern District of Michigan. Western District of Michigan is headquartered in Grand Rapids. Eastern District's headquartered in Detroit, Michigan. The U.S. Attorney works for the Attorney General of the United States. The gentleman I got pictured here is Andrew Burge. Andrew's the U.S. Attorney for the Western District of Michigan. Again, appointed by POTUS, confirmed by the Senate, serves at the pleasure of the President. So that if the President, again, doesn't like the job that Mr. Burge is doing, he can ask for his resignation, and Mr. Burge has to give it. Andrew is responsible for a judicial district, the Western District of Michigan, and he's considered the Chief Law Enforcement Officer for that judicial district.
So if you're kind of like going, what were those districts? What do you mean by those districts? If you remember in our last PowerPoint that we did the week prior, I believe it was, the federal system had it broken down with all the different districts of the United States. So if you need to refer back to the previous PowerPoint, it'll show you those districts and kind of what Sean's talking about right now. But now let's take a look at the state system. Now, Sean, would there be, like under the prosecutors, would there be a state attorney general?
Yeah, and now the state attorney general, here in this slide, you'll see Dana Nessel is the attorney general for the state of Michigan. She is elected She's elected by the citizens of the state. She's not appointed by the governor, she's not appointed by the president. She's an elected official. So therefore, she's only responsible and answers to the citizens of the state of Michigan. That's different than the U.S. Attorney and the Attorney General of the United States. But she's responsible for enforcing state statutes here for the state of Michigan. She's considered the chief law enforcement official for the state of Michigan.
So one thing that we're also gonna kind of noticing with the state systems, you're gonna find it's more elected positions than with the prosecutors than appointed by the president that you'd see in the other sides with the federal prosecutors. If we move on to the county prosecutors, dealing with the counties, now each county will actually, be broken up by county, and they'll each have their prosecutor, in which we also have them elected here in, Kent County. So, Sean, you wanna hit on this one a little bit?
Yeah, so again, the county prosecutor, it's now we're winnowing down where now we're talking about the county. So instead of talking about the state, we're now talking about the county. The county prosecutors elected by the citizens of that county or of that jurisdiction. As I previously referred to, you'll hear them referred to as district attorneys or county attorneys, or you'll hear them referred to state's attorneys, and they're responsible for prosecuting state and county laws. They're the chief law enforcement officers in that county. It's not the sheriff of the county, it is the prosecutor.
So you're gonna find a lot of the stuff that happens as we start breaking it down. Each prosecutor has their own jurisdictions with the courts. So you have to kind of look at, okay, so how does this operate if, let's say somebody steals a car in Kent County. So they do a UDAA, unlawful driving away an automobile, and they steal it maybe at gunpoint, okay? So they steal at gunpoint, they got a gun on them, now they go over to Montcalm County, and they do a homicide in Montcalm County. Well, where to the case at this point, he gets arrested, let's say after committing the homicide. Now the question is, well, where do we take the crimes? Well, each act happened in a different jurisdiction. So the prosecutor's office here in Kent County would take the UDAA, and then the homicide would actually be taken by the prosecutor in Montcalm. So we're gonna talk about a thing called extraditing in a little while here, but basically what you have to understand is when we get down to the county levels, each prosecutor at each county level has their own jurisdiction in that area. Anything to add with this?
Well, in Greg's example too, on top of that, you've got potential federal charges, because you've got a carjacking now that you can charge federally. Although there's no statute for the homicide, there is an enhancement in sentencing because the death resulted in the federal crime. The prosecutors, what we want you guys to take from this slide is that prosecutors are officers of the law. Okay, they've got distinct jobs and responsibilities throughout in the criminal justice system. They've got a lot of discretion. They've got a lot of discretion on what to charge, what not to charge. An officer can arrest somebody on probable cause, but that doesn't necessarily mean that case is going to trial. The prosecutor may say, hey, look, it's a good arrest, it's a good arrest, but I just don't think I can prove it beyond a reasonable doubt in a courtroom, so they may dismiss that charge or they could potentially stop a prosecution as the trial goes on because new evidence has come to light. So prosecutors have a lot of discretion in what they do and how they do their jobs.
So you'll see, like some people will come up and say something, you see stuff that arises. As a matter of fact, last year there was down in, was it Orlando, where that one guy came up at the city council meeting? Or it was Miami or Orlando, somewhere down in Florida. All of a sudden, one of the county electives stood up and a guy gets awarded Officer of the Year. And this official starts tearing this officer down, saying he unlawfully arrested him. Well, he didn't unlawfully arrest him. The guy actually had probable cause to arrest him. It was just the prosecutor felt, yeah, it's enough probable cause to arrest somebody, but we don't feel comfortable charging it because we don't know if we'll actually win it. So they never went further with the charges. That doesn't mean it was an unlawful arrest. What it basically means is, yeah, you had enough probable cause, but you just didn't have enough there where the prosecutor felt comfortable in actually bringing those charges to get an actual conviction on, which that happens. But don't get confused with the fact that it's an unlawful arrest because the prosecutor decided not to charge them. That's not necessarily always the case.
You're talking about two different standards. You're talking about probable cause standard to arrest somebody and proof beyond a reasonable doubt to convict somebody. And if a prosecutor doesn't think they can get a conviction, they're not going to take a case to trial. very few times will they roll the dice and say, we'll throw it to the jury and let the jury make a decision. That never happened in the federal system. I can assure you that. They're going to require that they have proof beyond a reasonable doubt before they take a case to trial. Otherwise, they're just not doing their jobs.
So this slide is actually pretty interesting because it goes back to actually the last journal that you wrote based upon Brooks. And we look at the prosecutor being an elected official. There's a fine balance because you want the people's vote, but yet you also still got to abide by the United States Constitution with due process with the 5th and 14th Amendment. And what we saw in that Brooks is, Sean and I were kind of laughing a little bit like going, well, hold on a second. The Atlanta Bureau of Investigation is still investigating the case dealing with Brooks, but yet they're already bringing charges on him. And it gets to the point where you kind of scratch your head and you're saying, is this prosecutor now trying to please the people by sacrificing officers by not giving them due process? The question is, as a prosecutor, it's a fine balance. One, they look at you as a crime fighter, right? People are like, wow, look at you. You're bringing justice to our community. That's an awesome thing. But on the flip side of it, too, when you got that elected position, are you trying to put the favor now and do whatever you want for the citizens and not even look at the Constitution anymore? Or do you want to uphold the Constitution and be fair and just let the people in your community respect you because you are doing stuff based upon the legalities of the law? I don't know, Sean, you want to add anything to that?
This also delineates the differences between a federal prosecutor and a state prosecutor. State prosecutors are elected officials. They are responsible to the citizens of their jurisdiction that elected them. And that may be good, may be bad. Federal prosecutors are appointed individuals, so they are more along the role of the crime fighter, where they really aren't responsible to the voters in that jurisdiction. So it's a duality that a lot of prosecutors struggle with because their main job is to met out justice, and if they're not doing that, they're not doing their jobs. And that doesn't always mean charging every case you get or declining every prosecution you get. It's a fine line that they have to draw, but this slide right here with the dual roles, that dual roles, you might as well put the prosecutors and elected official, you might put state prosecutors there, and the prosecutors as crime fighters put federal prosecutors there.
That's great, that's great. Defense attorneys, oh boy. So here's the thing, a lot of people would be like, well, you know what? I'm a police officer, and maybe they go into law. And maybe you see some police officers, actually, they go into the prosecutor's office, they become like actually assistant prosecutors, and maybe even the prosecutor of the county, and they're extremely good attorneys. But you also see law enforcement officers go into law and actually become defense attorneys. And they're exceptional defense attorneys because they know the inner loopings of basically finding technicalities to kind of get cases thrown out of court on. But being a defense attorney, I think, is often more difficult than what a lot of people think. And I've seen, I don't remember if you remember this with Michael Jackson, not Michael Jackson, the famous hip hop singer, okay? But there was a shooting in Grand Rapids that occurred with Bemis, I think he was part of Bemis, one of the gangs. And basically Michael Jackson got so upset, he assaulted his attorney in court and was yelling at him and basically threatening his attorney. And his attorney, his defense attorney, going, I'm here to represent you. And when you're dealing with certain individuals and you're defending them, you really don't know who you're going to get that is your client. And they could turn on you in a second. And there's a lot more to it. So not only are you defending that client in a way, whether you agree with maybe something or not, you're defending them, and that's your legal responsibility to defend them in the court of law. Whether if you even think they're guilty, you still got to make sure that you defend them in the right way, and that can be a tough balance. But you're basically working with a prosecutor, working out any plea bargains for your client. So instead of running something to court, you're like, oh man, you're kind of guilty here. Let's see if we can work this out with the prosecutor to get a lesser charge on you. So you're still working it for them, but yet you're still there to uphold the justice and due process. Yeah, what do you say about that, Sean?
Yeah, I always like working with defense attorneys. In 25 years, I had one guy that I really could not trust. Most of the defense attorneys that I dealt with were professional. It's not like you watch on Law and Order or any of these other cop shows. Defense attorneys have a hard job to do. For the most part, they're trying to you know, they're trying to make sure that they are taking care of their client to the best of their ability. And sometimes that means having their clients plead guilty, you know, to a lesser crime or whatever, but sometimes that's the best you can do for your client. And a lot of times these clients that they're dealing with don't want to hear that. They think they should be getting off scot-free, and the attorneys, you know, having to get what they call client control is one of the most difficult aspects of being a defense attorney. So I've seen some.
Can I mention one?
Yeah.
Okay, so there's one defense attorney that stood out where I was like, okay, this is like the typical thing when people think about defense attorneys being horrible. So this defense attorney, basically the case that I had was, there was these two moms, and they had their son in one of the schools. Well, they went to have, their son was having issues disciplining, like just talking back to the teacher, beating up students in the class, and just having issues. So they go to have a conference with the teacher, and this lady was maybe like 5'2", maybe 100 pounds at the most, right? And anyways, this is the teacher, so she sits down across the table from the two moms, and then the principal sits at the end, and they're gonna have this meeting about their child. So the child is now sitting with the moms. Well, the one mom gets upset at the principal and teacher, grabs a chair during the conference, picks up the chair, and goes to hit the principal with a chair. The other mom pushes the mom aside, and the chair falls on the ground and just misses the principal. Well, they call me, I'm the responding officer, I get there, I investigate the case, the chair's like laying like on the ground, kind of exactly how they explained it. I get written statements from the teacher, from the principal. The moms had already left, they went home like, as soon as that happened, they ran, they got out of there. So then I went to follow up to interview the moms at the home. So I get to their apartment and they plead the fifth, they're not gonna talk. And I'm like, okay, that's fine, you're right. So at this point, I write down everything I have, I give it to the prosecutor. Prosecutor reviews it and actually issues a warrant for felonious assault because she took the chair and tried to hit it with a chair, okay? So long story short, the defense attorney comes in and we're doing the plea bargain deal, and I'm sitting there with the prosecutor, and their defense attorney comes walking in. It says, out of all the years I've been practicing law, my client's innocent in this one. And I'm like, innocent? You got a school teacher and a principal, and then I took pictures of the scene. I'm like, out of anything, this is probably one of the most easiest cases ever. So it goes to, they're taking it to trial. So I'm sitting up there, and it's my turn to testify. And he said, Officer Eisenhoff, could you tell me what the scene looked like? And I explained the scene exactly what it looked like when I got there with a chair laying down, like right where the principal was sitting, and it was, you know, it was laying on its side and stuff. And as a matter of fact, right when I got done saying that, he slams his hand on the desk and goes, liar! And the judge actually had to reprimand him right there in court, like going, what is this going on? So what I'm trying to say is this: when you see some defense attorneys, there are some really interesting ones where you literally are like, where did you come up with this one? And where are you going with it? That's the next question. But anyways, I mean, you get some good ones and you get some ones that are like, how did you pass law school?
I've had 1 in 25 years that I told something in confidence and later heard about it. He asked me about it on the stand. The rest of them are very professional. They got a job to do, and for the most part, they do it very well.
Yeah, so I mean, when you start looking at the slides here and stuff, you talk about, you got to have the defending the guilty, because there are some people who are actually innocent, right? And the last thing that we want to do in due process is find somebody who's actually innocent guilty. In the court of law, defense attorneys are very important part of the process of the court system. Anything to add with this, with Gideon?
Yeah, the public defender, if you can't afford one, if you can't afford an attorney, one will be appointed for you. We all heard the Miranda warnings. There are certain eligibility requirements that you have to meet in order to be eligible for a public defender. You have to be what is known as indigent. You have to not have the financial ability to pay for an attorney. Now, in the federal system, some of these attorneys that are on the federal bar as defense attorneys are phenomenal. Matter of fact, my personal attorney is on the federal bar, so if he he's been summoned into federal court to work as a defense attorney for people that have been arrested for federal crimes. I mean, he's a great attorney. So these people that work for the public defender's office are quality attorneys. The effectiveness of these public defenders, there's been studies done out there where the defendants, the rate of conviction for public defenders versus private attorneys is about the same. And I think that kind of speaks towards law enforcement in general. I mean, we're bringing cases to court that they're good cases. I mean, they've been well investigated. The conviction rates are the same. But where the public defenders get overwhelmed is their caseloads are just so high. It's just like the prosecutor's office. They're carrying probably, here in Kent County, they're probably carrying 150 to 100 cases. I mean, it's unbelievable how many cases these attorneys have to carry. That's why, Greg's talked about the plea bargains, why that's so important to our judicial system, because if every one of these cases went to trial, people would spend they'd get time served in the county jail for any sentences they got, because they would have spent 4 or 5 years in jail prior to their trial coming to fruition.
Right, and we kind of already spoke a lot on this slide right here, dealing with conviction rates and whatnot. When we start breaking stuff down though with that attorney relationship, we talked a little bit about that. And like with the Michael Jackson case, you'll see other suspects literally ripping out their defense attorneys. You'll see it on big high profile cases dealing with certain suspects, but you also see some weird relationships between the defense and their client. And I had one case, it was a retail fraud. It was clearly a retail fraud. The lady even wrote down her name on a slip and said, could you pull these items for me? And then she concealed a bunch of merchandise, left in her car, and the officer working the east side of the city said, hey, do you see this car at this house? And it was on the west side of the city where I was working. So I went to the house, and sure enough, there's the car sitting in the garage. Well, I knock on the door, and the lady answers the door, and she has the registered owner of the vehicle that did the retail fraud. Well, the lady who did the retail fraud also had a warrant for her arrest for retail fraud. So she's done retail frauds in the past. Well, long story short, she gives me consent to search the car. I didn't find the items in the car that they said. But I did arrest her on the warrant for retail fraud. Well, they have her on camera actually concealing stuff. And long story short, the camera video, it was kind of difficult to see her actually concealing, but I mean, there was video of her in the store and whatnot. And then the store employees showing what was actually gone. So long story short, it goes to trial, and the defense attorney doesn't say much, but the prosecutor said something. When we start talking about the courts, it's really, really crazy when you get juries in there. And when we start talking like O.J. Simpson in that last couple slides, you never know what's going to happen. This is a clear-cut, dry case that we had together. And the prosecutor said to the jury, he said, he's talking about the Goodwill. The client said that she was window shopping at the Goodwill. Well, the prosecutor comes from a pretty prevalent family and very wealthy, kind of went through law school, parents paid for all his law school and stuff. And he says, I don't know of anybody that window shops at the Goodwill. And all of a sudden, this mom, middle-class mom, literally her face went, what? Like, looked at him like, are you kidding me? And go figure, the defense attorney hardly spoke at all during the whole trial. Literally, I mean, it looked like he was lost. And it got to the point where I was like, man, that defense, he's not really representing this woman well at all. And the woman was cool. And I was like, I'd be a little upset if I was her because he's not doing anything for her. But then all of a sudden I saw that look of that mom and the prosecutor said that. They went back, came back about 5 minutes later and said not guilty. And I was blown away. And I mean, there was there was some evidence out there on her. But I think just because that statement that prosecutor made, they said no. It was interesting. I wanted to add that because when you start thinking about defense attorneys, like he knew his client was probably guilty and that's why he was sitting back there not saying much. But him not saying much actually won the case. Yeah, so it was interesting. You want to hit anything with the defense attorney on relationships?
Yeah, again, it's at client control is probably the hardest part. Greg and I both had cases where defendants have gotten into physical altercations with their attorneys. I had two of them where they got in physical altercations in court, had to be removed from the courtroom. The attorney-client privilege, that's something you need to touch on. The U.S. versus Zolan, what that refers to is a Supreme Court case where defense attorneys, it covers the attorney-client privilege. So this comes up a lot with cases involving organized crime, where the attorneys sometimes get drawn into illegal acts. They may disclose those contexts of the conversation with their client if that information concerns a crime that's yet to be committed. I had this case where a guy threatened to kill me, and in the elevator coming down the federal building, and as soon as the attorneys got some distance from him, they called the FBI office to let them know that their client had just made that threat.
So as we talking about the pretrial, there's a lot of steps that occur with the pretrial. You also have to look at what is eligibility for bail. So when we talk about cruel and unusual punishment, the question is excessive bail falls under there, okay? So what are the amounts that are set? Can you let this person out? Are they safe to be let out? And at what point do you say, this is a number where you don't want this person to get out, right? Because maybe they're a serial killer, I mean, like hardcore. And the judge, everybody knows it. I mean, there's person may even admitted it, that they got a problem with it. Well, at what point do you set that, bail to high enough where they can't afford it to get out? And is that right if they do that? You know what I mean? You want to touch anything?
Yeah, that's a state issue. In the federal courts, you can have a what they call pretrial detention in federal courts, where you can move that a defendant be held without bail until their court appearance, and you have to show two things. One is their dangerousness to society, and two, the other prong is whether or not they'll show up for court. So they'll have a separate hearing on that. That's part of the pretrial procedures in the federal court.
So like you just talked about, so on this slide here, you're going to see, pretrial bail is provided under the 8th Amendment, but it's not guaranteed.
Right.
So when you sit back and you're like, okay, well, should this person be out or not out? I mean, it depends on the totality of circumstances and the wisdom of the judge sitting at that seat to give that, whether yay or nay with that bond set. The question is this: where does a judge sit? You may have a really liberal judge that sits totally one way, and you may have a very conservative judge that sits another way. Now, do you get to pick your judge? No. It's when we started, we talked about judges in our last PowerPoint, and we talked about the state ones being elected officials here in the state of Michigan. And as a matter of fact, we questioned you. Should they be elected? Or should they not be elected? Should the Supreme Court justices be elected or not elected? Or should they be appointed like they are right now? And we ask those questions because you have to think about, well, who's actually sitting in the seat and how much power do they actually have? And when you start getting judges sitting in the seat, they're making big decisions on your lives. So I think it's very, very important to look at, because if you think about it, if in Kent County, say you got somebody for drunk driving or something, now, how long are you going to put them in jail for that drunk driving, especially when there's no beds available at Kent County Jail? So they got to look at how many beds are available wherever they send them. So
and currently, you also got to look at COVID.
Yeah.
You're in the middle of a pandemic. You may not want to stick anybody in a jail cell right now because they may be having a COVID outbreak. So there's a lot of things that judges take into account when they make those decisions.
But I also like the thing with bonds too. A lot of time at Kentwood, we took bonds on the street. So like let's say I stopped Sean for driving with a license suspended, and he has a warrant for driving with a license. Well, I'm sorry. Say I stopped Sean for just something taillight out, and he has a warrant for retail fraud, and it has a $100 bond on it. Well, good. Okay, so I can arrest him there on the street, but he's like, hey, I got $100. At that point, what will happen is, as long as he has good identification, I'll take his $100 and give him an appearance ticket to show up like 2 Tuesdays from now for that crime at 9:00 a.m. And if he doesn't appear to that, well, then a warrant will be issued again for that. But on the same end, the court just got some money. So, you're still getting money to the court, providing it. So I think that the bail or the bonds on the street actually really help in a lot of ways, because it is still getting money based upon what that person is to say, yeah, you're gonna appear based upon, I want my money back, right? Anything else?
No, this slide right here is just basically talks about the bail amounts for various crimes. Obviously, murder bail amounts are gonna be a lot higher than a property or an assault crime, so we'll blow through that one pretty quick.
You wanna talk about indictments?
All right, so the indictments, information's preliminary hearings. We're gonna compare and contrast these in the next couple slides. Prelim hearing is basically where, in state court, where the judge hears from both sides and determines whether or not there's probable cause for the case to move forward. Discovery happens at this point, where the defense attorney should get all the evidence in the possession of the prosecution related to the case. I'm sorry, I might have gotten a little ahead of us. Okay, indictments. So, in some state jurisdictions, there's a grand jury replaces the preliminary hearing. Definitely in the federal system has a grand jury that sits all year round. So federal prosecutors, AUSAs, can take those cases into the grand jury and present it to the grand jury, and the grand jury makes a determination whether or not there's probable cause to file charges against the defendant. The state system has a similar system. Here in the state of Michigan, they have a one-person grand jury. It's usually a sitting judge that the prosecutors and investigators will present their evidence to, and that state court judge will decide whether or not there's probable cause to move forward.
You know what, I want to add one thing in there too.
Go
You
ahead.
also, because I don't think we have it in the slides, but you also have something called a suppression hearing at times, where basically defense will say, well, hold on, this evidence was taken illegally. We want a suppression hearing on this to see if we can get this evidence thrown out. You'll see that here and there too.
Yeah, that's part of the pretrial also after the defendant's been arrested. Grand jury's gonna hear evidence presented by the prosecutor. Granted, it's all one-sided, but the defense does not get to present their side of the case. That's what the actual trial's for. The grand jury just basically hears the prosecution's evidence in the form of photos, documents, testimony, tangible objects on why the state thinks that the defendant committed the crime that they are being charged with. Information replaces the indictment in the federal system, serves as a formal charging document. Sometimes, I've had it happen numerous times in a bank robbery where the defendant gets arrested immediately after the bank robbery. Take him down, I'll interview him, I'll have him basically write out a confession, have him sign his pictures of him in the bank saying, this is me robbing the bank. And the defense attorney gets that and says, what am I supposed to do with this? He basically confessed to everything. So we'll plead him out to an information where the prosecutor will prepare an information. It'll go before the magistrate judge and they'll plead guilty to an information.
So that's what you'll see in, I think it's the next slide. Yeah, this one right here. So that's what you'll see based upon what you just talked about there in that slide.
Yep, so it's just 3 different ways of charging a crime. You've got a preliminary hearing, you've got an indictment, you've got information.
Now we get to plea bargains. Plea bargains are great. Why? Because it keeps our court system moving forward. And if we ran every single case for every single arrest, for every single charge that was brought out, the courts would be backed up they'd probably be backed up 50 years back. But the plea bargain basically works out, let's say I get arrested for drunk driving, possession of cocaine, and something simple. Let's say I had possession of cocaine, drunk driving, and my license was suspended. Okay, so we got 3 charges that we have. Well, at this point, what would happen is the prosecutor would sit down with the defense attorney. The defense attorney would say, okay, it's a cut and clear case that my person had cocaine on him. How about we do this? How about you drop the possession of cocaine, which is a felony, and you give us the 2 misdemeanors, which is operating while impaired, drunk driving, and the DWLS. We'll take those 2 if you drop the cocaine. Prosecutor may say, okay, we could do that. Or the prosecutor might say, how about we charge with the possession of cocaine and drop the 2 misdemeanors and we give probation. Something like that. That's the plea bargaining thing. So then the defense attorney will go back to the client, talk it over with the client. They'll decide, yeah, you know what, let's take the deal. It's a great deal, or no, it's not. Let's go to trial. But that's kind of how the plea bargain kind of works, Sean.
Yeah, in the plea bargain, part of the plea bargain is that right here, the defendant's got to make what's called an allocution, where they have to tell the judge what they did. And that, number one, it's under oath, and number 2, they're giving up their Fifth Amendment right. So they're basically saying, this is what I did, and they have to allocute as to how they committed that crime. And the prosecutor's going to, as they're making their allocution, they're gonna make sure that they get in the parts that constitute that crime. And what I mean by that is, like, for a bank robbery, they're gonna have to allocute that they took money from a bank that was in the care and custody of another by either threat or coercion. Those are the 3 parts that make up a bank robbery case, that make up the bank robbery statute in federal court. And if they don't state those, how they did that, then the judge is not gonna take that guilty plea. And if they later come back and say, well, you know, that I was made, that guilty plea, my defense attorney made me do that, and I didn't freely do that, the court can come back and prosecution can use that statement against them in the circuit court, in the Court of Appeals, because they have waived their Fifth Amendment rights.
So if I were to see a test question that talked about plea bargaining, and it said that it's up to the prosecutor, defense, and the client, and that's all, to agree on the plea bargain, is that a true or false?
It's not, yeah, it's wrong, because it's actually up to the court. The prosecution can agree to it, the defense can agree to it, but unless the court agrees to it, that plea bargain is not in effect.
That's a big deal. Okay, so we kind of talked a little bit about this slide right here of how it best works. It can work out for, if I know I'm guilty of something, I can get a better deal, right? So there's a lot of pluses and negatives to it. Do you want anything on this or no?
No, most of the stuff we've already talked about, but these are all reasons for why there are plea bargains in our system.
You might recognize this cartoon figure here.
It's Lori Loughlin from, was it Full House?
Yeah. You go to trial. I talked a little bit about the trial. That was like, it was clear cut. Where I'll tell you what, this girl's guilty of the retail fraud. The jury came back not guilty. So you're going to look at a lot of different things here dealing with. So what if it goes to court and the news media is showing like this person's guilty? Well, the question is this: are you seeing every single thing and every piece of evidence that's brought forth to the jury during that time? Because remember, they're looking at totality of circumstances. And it's up to the prosecutor to prove beyond a reasonable doubt. Well, what if we're sitting on a jury and Sean says, yeah, I think it's beyond a reasonable doubt that this person's guilty of it, but I'm sitting back, I'm having doubts. Like, I don't know, man. Like, if I say, yeah, they're guilty, will I be able to sleep at night, you know, knowing that beyond a reasonable doubt, yeah, this person's guilty? So we might have a hung jury. I mean, things happen. I mean, you want to add?
Another reason for pleading not guilty is you can use that as a bargaining chip with the prosecution.
Yep.
Try to get yourself a little better plea bargain instead of from the prosecution. Another reason is you may have a questionable search, or you may have some questionable constitution or questionable procedure that the police did. Maybe they slapped a GPS tracker on your vehicle and didn't obtain a search warrant. So now you can challenge that evidence right there, because that evidence puts you in the same place as the crime occurred at the same time, but now you can challenge that on constitutional grounds, saying that they invaded your privacy. And then you can also submit a, what they call the affirmative defenses. So guilty, going to trial, I don't wanna say rolling the dice but it is there are certain things that you can use as a defendant to further your case.
Yeah, because if you plead guilty right away, it's kind of like when you go to, okay, so let's say you're gonna go buy a car, and the sticker price says $26,000 on it. And you're like, $26,000, I'll buy it. You buy it. Well, you got the other person that goes, I'll give you $24,000 for it. It's kind of pleading not guilty, like, okay, I know I'm guilty, but I'm gonna plead not guilty because I want to get a deal here. I don't want to get 5 years in prison. I'd rather get like the minimal I can. Can I get probation out of this? And that's what you're talking about there. I mean, it's actually kind of smart, pleading not guilty.
Yeah, and a lot of defense attorneys are most defense attorneys, I shouldn't say most, almost all the defense attorneys I knew, that I worked with regularly, they know how this works. And they got the best deals they could for their clients. So, but that is an option, to take it to trial. And, there's nothing to say that once you're in trial that you can't all of a sudden decide to plead guilty also, if the trial's not going your way. So, pleading not guilty is always an option.
Right. You can review this last slide in that video. Sean, anything on it?
Yeah, this video is going to give you some background on the bail and excessive bail, and these are some of the questions Greg and I would like you guys to contemplate. Is bail constitutional? And the inability of somebody to pay bail lead to people pleading guilty. If I can't pay the bail to get out of jail, I might as well start the clock ticking right now and plead guilty to it, even though I didn't commit the crime, because it's only going to amount to a 6-month prison sentence. But if I wait because I can't pay the bail, I'm going to end up spending a month and a half in jail. I might as well get it over with and plead guilty to it so I can get back out, get a job, and support my family. So this video that you guys are going to watch is going to bring up some of these issues. We'd like you just to reflect on these things as you write your journal.
And this is when you were overseas, was it not?
Yeah, it cracks me up because you got the Afghan fried chicken and the guy with the AK standing out front of the place. Just kind of cracks me up. If you got any questions, feel free to email us or catch us during class. Otherwise, hope good luck with your journal and good luck with the test.
See you later.